All right, folks, for scheduling, tomorrow, we're going to start at 9. 9:30. 9.
Robert, I think someone may have a problem.
Who's got a problem with 9?
Aside from me? Aside from me?
Yes,
Oh, sorry.
I don't have a problem, I'm not sure that I can make it by 9. I mean, I have to drop off my kids in the
Oh.
morning, so I come right after.
Can you do your best?
Yeah, of course.
All right, I'm gonna order everybody to be here at 9, but try to get here at 9, but if, you know, you're late, you're late, I understand. Dropping off your kids is important. So be here at 9-ish. Okay? All right. We're back on the record, all parties and council adjourned are present.
Okay, folks, so I think we left off when I was discussing with you all the whole notion of the person who used to be Relly is not Relly anymore, apparently, who came back at 11:09 to the scene to retrieve shell casings. Now, again, his story changed. Ultimately, he said it wasn't him, so some mystery man showed up at the scene at 11:09, apparently. But one of two things happened here. Either that really was Relly, like he first said on the video, coming back at 11:09, staying for 2 minutes, returned to the scene, and he lied, of course, then about being there with his girlfriend, if that was him, and about taking photos of the shell casings while there, because those photos weren't taken until 11:45. Or the prosecution has absolutely no evidence whatsoever that he ever returned to the scene, ever. Whichever one you choose, the prosecution has no evidence at all that Relly actually recovered those shell casings from the scene. You know, he could have called his girlfriend, Miss Parker, to back up his claim. Yes. She was probably busy doing what she does, but she didn't show up. Their burden, corroborated with witnesses, me. The word of Relly, I think, is fair to question. There are a lot of things in this case that are going to be easy to corroborate of his word, if they're true. I'm going to show you a little list. Those sort of cool I put together, but not yet. But there is no corroboration, and they couldn't. Lydia Parker could have come in here and said, yes, I went back with him. We found 2 shell cases. She's still his girlfriend, apparently. No evidence whatsoever that he took the shell casing off the scene. While on that point, by the way, the photos taken with Relly's iPhone of the alleged shell casing, allegedly taken at the scene, but not until 11:45, an hour and a half afterwards, they had time date stamps on them. But what you didn't see from the prosecution was the GPS location data for those digital photos on Relly's phone. Why? I mean, you know, they didn't show you, what else they didn't show you was GPS location data from Relly's iPhone to show you where Relly was on November 6, 2021. That would solve a lot of mysteries here. It's not like they couldn't have done it. GPS location data from Relly's iPhone, which they had. That would have answered all the questions. Could have corroborated it or not. After all, you heard that law enforcement, in this case, went out of their way to get a search warrant to obtain GPS location data for ASAP Illz iPhone, just to show that he was, one, near Selma Avenue and Vista Del Mar about 10:12 p.m. on November 6th. It showed that in his location data. And he was near Rocky's residence at 11:11 p.m. that night. That from Detective Flores' testimony, lest there be any confusion. The question was asked, and specifically, it's important because it showed they could have gotten GPS location data from their only witness who's not corroborated, and whose word may be a little shaky. And specifically, the T-Mobile information law enforcement obtained authorized to search Illz Elijah Ulunger's, ASAP Illz, his call detail records, and his GPS location. Detective Floor is correct. And the GPS location data, I should say, answer yes, okay? And those records, the GPS location data that you all were able to obtain showed that Elijah Ulanger, ASAP Illz, cell phone was near Selma Avenue and Vista Del Mar at approximately 10:12 p.m. on November 6th. Answer, I believe that's correct. Question, those records also show that Illz, I'm just going to refer to him as Mr. Illz for the purpose of moving this thing along a little bit. ASAP Ill's cell phone was near Mr. Mayers' residence at 11:11 p.m. later that night. Answer, yes. Subsequently after, yes. Well, what that shows you is that not only had they had the ability to do that, they in fact did it. But why just for Illz? Why not for Relly, who claims he came back and found shell casings? That would put an end to this mystery. Was he there? Was he with his girlfriend? Was he not there? You heard again. There was no dispute, by the way, about Illz that he was at Selma, Vista Del Mar and Selma that night during the incident. You see him on video. And rather than looking to see where Illz was at 11:11 p.m., why didn't they use Relly's GPS data to show you where he was at 11:11 p.m.? Was that him? Was that not him? Did he ever go back at 11:45? This would have answered all your questions, either corroborated the story or not. Would have put the lie to it again. It would have also shown you where those iPhone photos of the shell casings were taken. Instead, you have to take his word for it. You just have to take his word for it. Yes, they could have done it. They did it with Illz for some reason, but not for Relly. So just take his word for it. If the word of any witness ever deserved to be tested in this case, it's Relly. I mean, it's a man whose tongue is a stranger to the truth. And they could have easily corroborated his story or shown that his story was not truthful. They just didn't do it. I want to pause here so this really sinks in. Detective Flores told you that he wouldn't want anyone other than the police taking evidence from the scene because that could hamper and hinder an investigation. This is obviously fairly important. As a detective, I asked him, you'd agree when conducting an investigation of an alleged shooting, you wouldn't want anyone who's not law enforcement removing evidence or taking evidence from the scene, right? Answer, correct. Because that could tamper and hinder your investigation. Answer, it can. And that makes sense, because once evidence is contaminated, once an alleged crime scene is contaminated, there's no way to undo that, no way. You never get a second chance at it. If you want reliable information from a scene, it cannot be tampered with, it cannot be staged. If it's staged, it's useless. It's pointless to review it, because whatever you see, you have to reject. You have to. And that's exactly what Relly says he did here. And that's why it was even more important for the detectives to test his word by looking to corroborate it, but they never did that. To be clear, the prosecution just wants you to take Relly's word that he found shell casings at the scene. That's it, just take his word. After all, they presented to you nothing to corroborate it when they easily could have. And just ask yourselves, if Lydia Parker, Mr. Relly's girlfriend, could readily corroborate his claim, don't you take the word heard from her? The fact is, Relly didn't want her anywhere near the courtroom. Anywhere near the courtroom. Remember when I showed him a picture of Miss Parker, his girlfriend? And I said, is that your girlfriend? He said, I don't know.
Is this Miss Parker? You don't know if that's your girlfriend?
I think TV does put 10 pounds on you, but we're disturbed by that photo. But Anyway, back to more important things. What he just said was, I don't know if that's my girlfriend. Just anything he tells the truth about, I don't know if that's my girlfriend. That's not, I don't know. That's either yes or no. He couldn't recognize his girlfriend at one point. He said, oh, because she had makeup on. I mean, we're not talking about clown makeup, right? I mean, she literally said, my girlfriend. Why lie about that? Aside from his name, I don't even know if that's really his name. Did he not lie about anything in this case? I mean, you know that wasn't truthful testimony. He didn't want the only person who could or couldn't corroborate his story to be anywhere near this courtroom. And I submit neither did they. The judge told you, the defense does not have the burden to do anything in this case. They do. They had the burden. We don't have to prove anything. We didn't have to introduce a single piece of evidence. We didn't have to produce a witness. That's because the laws of the United States and the Constitution demand that. But as a matter of fact, we had more substantive witnesses in this case to testify than the prosecution did. We want to give you the complete picture, all the evidence, because we want you to know the truth. And there's nothing to hide. Rocky did not commit a crime, not by a long shot. Why? Again, and you need the answer as to why they didn't show you the GPS records of Morelli, when it could have shown you where he actually went after the incident. From the incident, where did he go for that hour and a half? And where did he take those pictures from? That would have been important, especially if there's any question that that video may not have been shown to Morelli returning, if that wasn't him returning to the scene at 11:09, 11:11. So where was he really at that time? Unfortunately, we don't ever get to know the answer, because they didn't get his GPS location information. We're just supposed to accept his word that he didn't go somewhere else to get showcases. We just have to accept it. And the judge gave you instructions on this about the credibility of the witnesses, and it's in your, you can take it back with you there. But it says that a witness lies to you on an important fact of the case, or in his testimony. You can feel free to disregard the entire testimony of that witness, or you can just disregard that one fact and believe the rest. But he lied to you about so many crucial things. I'm not talking about his inconsistencies. Again, we'd be here until the summer. He lied to you about the most crucial facts in this case. You know, by the way, this is not someone who's uncomfortable around guns. You heard he owns a 9, he posted those pictures on the Instagram. His 9mm sticking out of his waist, he said. You heard he owns a 9mm semi-automatic. We've never seen proof or he actually obtained it. Second, he blatantly lied about his access to 9mm shell casings in Los Angeles. That's another account of perjury. And that was a big one. And we have to talk about this. We have to spend a little time on this one because what happened there was very crucial. He lied about having access to 9mm shell casings 2 weeks before the incident on November 6th. He lied to them. He lied about being in Los Angeles. He lied about having access to shell casings. He lied about shooting. I'm going to show it to you. This next episode is not even one lie or one perjury event. It was like a perjury miniseries, this next one. It was unbelievable. One lie piled onto the next one, you got caught with that, then he went to another. It was a glorious training. And you're gonna see it. I mean, I asked him first if he fired a 9mm weapon before November 6, 2021. Sort of an important fact. Because it would mean he had access to 9mm shell casings. First he said, no, absolutely not. Then I wanted to make sure, I wanted to almost help him give me the truthful answer. I said, well, how about at a shooting range a few weeks before November 6th? Did you fire a 9mm at a shooting range? Right, hit them off on November 6th, 2021. He said, definitely not. And I repeat, I said, definitely not? And he got all belligerent with me, he says, you heard me, definitely not. I didn't even own a firearm, he said. I only got my firearm license a year and a half later. Listen.
Let's move closer to the time of the incident on November 6th of 2021. A few weeks before November 6th, 2021. And a few weeks before, you testified that you found shell casings at the scene. On the shell casing, you fired 9mm weapons at a shooting range, correct?
Definitely not.
Definitely not.
You heard me, definitely not. I didn't have a firearm. I only got my firearm license a year and a half later.
So, you heard me, like, you know, this. He did not like me, clearly. And of course, I asked him to confirm that answer. You heard me. Well, you asked me again. You heard me. Definitely not. I didn't even own a firearm. I only got my firearm license a year and a half later. Lies, 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 lies. And that's when we all saw the video of Mr. Efron firing a 9mm semi-automatic weapon on October 19, 2021, 2 weeks before the incident on November 6th. And I pointed out to Mr. Efron, I said, what you just told this jury was that before November 6, 2021, you didn't fire any guns because you didn't have your license. And then he said, no, unless I was at a shooting range. And I said to him, sir, I just asked you, were you at a shooting range? And you said, definitely not. And I asked you again, and you said, you heard me, definitely not. He just made stuff up as he went along. Look at this.
Mr. Efron, what you just told this jury,
I don't know what I'm doing. 316, 365 days I'll be here.
on per se.
Someone
Hold on. What you just told this jury was that before November 6, 2021, you didn't fire any guns. Because you didn't have license. You know that was
just last I went to a shooting range.
I mean, you just saw his testimony, which was about 1.5 minutes earlier, where I said, was that a shooting range at least? Maybe he did that? Definitely not. Twice, definitely not. And then explain why it was definitely not, because he didn't even have his firearms license or whatever. When he got busted with the video that he didn't think anyone had, because it was not brought out on his direct, of course, he said, I said unless I was at a shooting range. He just thinks he can make that up in front of you. Like, he just told you definitely not at a shooting range, and then just in front of you, like, I don't know, guys. I mean, there has to be a point in time where you have to be so offended by him just looking at you guys and lying. He's took an oath. An oath. You know what oath means? Absolutely nothing to him. Absolutely nothing. He didn't say that. That was blatant perjury right there. You just witnessed another count of blatant perjury. But what happened in his courtroom after that, I think made it worse. After, you're going to see it, what happened. Because this was now all about, okay, so now we got him firing a gun. Don't play that yet, please. We have him firing a gun before November 6, 2021. We have him firing a 9mm. He lied about it repeatedly. And then, so after securing the date of the 9mm firing of October 19, 2021, I tried to ascertain the location of the shooting range. And the prosecution then asked for a stipulation. You're going to hear it. That the shooting range was taken outside of California. And the witness all of a sudden adopted that. Let's look at this.
And where is it? And where is it videotaped? There's a tape of this whole thing, right? So we have a situation on that tape. On that tape, this is outside of California.
I don't know where it was taken.
There was this stipulation, but at the time, I believe all parties in good faith believed that the shooting range was outside of California. No one is at fault. It's what the parties believe at that time.
Well, I didn't believe anything, so I didn't know. But I'm not saying anyone's at fault. I'm just showing how it's played out with the witness. You pulled out the witness. How he adopted
The prosecution asked for a stipulation based on what has happened so far up until this point. They believed in good faith that it was outside California. The fact that it wasn't came as a surprise, I believe, to everybody. Go ahead.
Well, except the witness, which I don't argue.
Everybody accounts with it.
Yeah, not believing everyone counts it. I just want
Right.
to, just let this play out. How the
New
witness
Jersey or something like that, or like, it's not, yes, it's not.
The same objections, improper argument over this.
I explained it to the jury. Go ahead.
New Jersey or something like that, or like, it's not, yes, it's not.
Yeah, next line. Last line was not Los Angeles, or not LA. So anyway, the witness then said, after hearing whatever he heard in the courtroom, the banter, he then said, well, maybe it was probably New Jersey, something like that, but it's not LA. That he was able to tell you for sure. He knew that. So, understand what just happened there. The witness, all of a sudden, after lying about all those things we just went through, and I don't have to repeat them again, then heard argument and said, oh, but it's not LA, it's maybe New Jersey. Because being in LA, that would have been a problem. But something happened over the weekend, little problem for Mr. Rowe. See, on Sunday, between 2 p.m., and he was on Friday, that was on Friday. On Sunday, between 2 p.m. and 2:11 p.m., someone on Twitter posted a screenshot that you saw, heard about, of a video showing Relly at the shooting range that was played before you, alongside a picture of the Los Angeles Gun Club. Locations right there. They were the same. Relly was tagged on that, everyone was tagged. So what does Relly do? Sometime between 2 o'clock and 2:50 that same day, immediately, he calls the prosecution and says, oh, I checked my Instagram account and I realized I was in Los Angeles on November 19, 2021. And I realized I was at a shooting range. And what's the reason the prosecution elicited from Relly as to why he made that discovery? Well, he was going back to check his Instagram account on whether the shooting range was in Los Angeles because he wanted to correct any mistakes he made to the jury. Something to say it straight, but that's literally what he said to you. He really was concerned about making any mistakes, so he wanted to make sure he checked his Instagram account to see if he made any mistakes. First of all, I asked him, see, your Instagram account doesn't have anything about the gun range. And he started saying, that's not my Instagram account. Well, aren't you really boss? Yeah, but, okay. Okay, folks. I guess he didn't go bother checking all his other so-called mistakes that he made. Just that one. Just that one that happened to have a post busting him at 2 o'clock. Within minutes, he calls the prosecutor. He was tagged on the post. Within minutes, he called the prosecutor. What a coincidence. You know, what about all the other mistakes? What executives did you meet at Capitol Records and Universal Records that you no longer can meet because of what happened here? You couldn't mention the name of anyone he met with. But he said they were on his phone. He could check his phone. Well, there you go. He was checking his phone to correct the record here. That didn't happen. How about the Miami property, Mr. Relly, that you invested in? I mean, last year, it was only last year, sir. You invested in Miami property. You post on your Instagram. I asked him, which property in Miami did you invest in? I don't remember which property. Lie. I mean, no one invests in property doesn't remember which property. Unless you're a gazillionaire, and that doesn't matter. And he's not. And then I asked him, well, how much did you invest in the property? I don't remember. He didn't go back and check that. So remember that, just remember that one, how that all played out here. when considering his credibility. Relly told you, just that there's so many things, the Miami robbery thing, that was just nonsense. But this was horrific. He got caught lying. It's made in New Jersey, definitely not LA. I went back and checked, it's definitely LA. That's clear perjury. So you know he didn't check his Instagram account, wanted to correct a mistake about whether the shooting range was in LA. That wasn't truthful testimony. You've seen him testify in the courtroom. He's a witness who told you when he said definitely not, he was committing perjury, because that was his then answer. He cleared that up. I'm going to show you this in a second. When he said definitely not to me, I questioned him. I said, you said definitely not. Because then he got busted with the Twitter thing. And he said, well, yeah, I just made that up because I didn't want to answer any of my questions, any of your questions anymore. He literally said to you, he just lied under oath on a very important fact, like whether he had access to 9mm shell casings, because he was tired of answering my questions. I'm just going to lie to you.
Well, this one on this topic, it's correct, just a few minutes ago. Okay. Okay, yes, I did. Okay.
Is that yes?
Yes. Did you look like you were confused by that question at all when you said, definitely not?
And to be honest, I just wanted to stop talking to you.
So, did you look like you were confused by that question because he said he was confused by that all of a sudden now? When you said definitely not, I didn't shoot a 9mm at a shooting range before November 6th, definitely not. So you look like you're confused, then she goes, to be honest, oh, here we go. There's a watershed moment. To be honest with you, I just want to stop talking with you, so I just said, Jesus. Just give me my $30 million and let's get this over with. He just told you to perjure himself. But you should believe him without corroboration. We all know it wasn't mere coincidence that minutes after that post that he was tagged on, he told the DA. He called because he knew what was coming the next day on Monday morning. He knew it was coming. And as for the prosecution wanting to correct that mistake, I'll hold that. Let me move on. But again, that is not a minor factor in this case. That's not a minor factor. And it's not a game. This is life. Whether their so-called victim, Tyrell Efron, had access to 9mm shell casings just a few weeks before he claims to have found 2 9mm shell casings in Los Angeles. Yes, he did, in the same city. He had access in the same city. Here's the funny thing about facts. Because facts weren't getting in his way. But the funny thing about facts is this, as John Adams once said, it's one of my favorite quotes. John Adams said, facts are stubborn things, and whatever may be our wishes or our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence. And you cannot alter the state of facts and evidence, no matter what Relly tells you, no matter how you want to interpret his testimony, no matter what they say to you. So with this evidence, ask yourselves, ladies and gentlemen, did Relly first lie to you about going to a shooting range where he had access to 9mm shell casings, and then lie to you again about having access to those 9mm shell casings here in Los Angeles? I mean, why would he do that? Why would he lie about those two things? There'd be no reason for him to lie about that unless it was to cover up something about those 9mm shell casings he claims he recovered. No reason to lie about that. You know exactly what happened, why he lied about it. As the police found when they got there, there was no shell casings there because he had a prop gun. He had a prop gun, as unimpeached witnesses told you. And he claims that he got these shell casings from the scene an hour and whatever later, a half later. And then he held them for 2 days, gave them to the police 2 days later when his extortion attempts failed. One thing's clear, the prosecution has not proven beyond a reasonable doubt that Relly did not get those shell casings from somewhere other than the scene. They did not prove that beyond a reasonable doubt. That's enough. That's enough. Beyond the fact that Relly had access to shell casings in Los Angeles now that we know, which he lied about, the prosecution presented no evidence, zero evidence whatsoever trying to corroborate Relly's claim that he actually found those shell casings at the scene. None. Not William Parker, not GPS location data, stuff that would have done it pretty quickly, pretty easy. Not a video. Relly first said that it was fake when I showed him that video. It was fake. He didn't think anyone knew we had those videos of him at a firing range. And by the way, we're not like master investigators. They were just on his phone. We just looked at every single thing on his phone. They had it too. They gave it to us. We didn't hear about that on his direct testimony. It would have been something to bring out to deal with. That wasn't brought out. If we didn't cross-examine him, we never would have known he was in Los Angeles 2 weeks before, with 9mm shell casings popping back into his head as he's firing. And he lied about it, perjured himself. There's only one reason you would lie about that. Covered up. Heard about the magazine. I won't get that magazine. The Block 43, Mr. Chris Lomas spent a lot of time on it today. And there was no effort made to test. Now, you heard the judge, he instructed that 2 weeks, I think it's 3 weeks ago now, he instructed there'll be no testing on that. 3 weeks ago, right after the trial started, 3 weeks ago, no testing. Here, going forward, great. That's January 2025. What about 2021, 2022? Well, not 2021, because they recovered in 2022, let me be fair. 2022, 2023, 2024. 3 years they had to take that magazine that they recovered and test it to the bullets recovered. They didn't do that. Instead, they spent their efforts having a ballistics expert come in, show you a very nice PowerPoint presentation, which in the end proved only that the shell casings possibly, there's that word again, possibly came from an aftermarket slide for a firearm frame that could possibly have been compatible with the Glock 43, or not possibly. I mean, literally, that was the import of that testimony. Possibly could have come from an aftermarket slide for a firearm frame that could have possibly, this is his testimony, possibly been compatible with the Glock 43 magazine, or possibly not. That was the ballistics expert's testimony. Possibly or possibly not is definitely not proof beyond reasonable doubt. In any event, Lou Levin told you that the Glock 43 magazine was his. He explained why it was his. Whether they want to mock him, mock his answer, he was in Rocky's house after they planned to go to a shooting range. He told you he had bought it, he owned the Glock 42. And magazines are stored all next to each other, 42s, 43s, and all that stuff. Lou told you. I don't know anything about this stuff, personally. But he went to the store to buy accessories. He mistakenly grabbed a Glock 43 magazine because they're all different models of Glock. The magazines are all stored together, he told you. He told you he didn't realize it until he tried to load it at Rocky's house in preparation for going to a shooting range. And then when his .380 caliber Glock 42 ammunition didn't fit, he tried 9mm ammunition from his Smith & Wesson, which he did. This is from his testimony. And because that magazine didn't fit any of his firearms, he left it at Rocky's house. Why? Why not return it? He told you. It was over an hour away from where he purchased the thing. It would have cost him more in gas than the $20 it cost him for that magazine. But one thing you know, despite all the questions from the prosecution, Mr. Lewin, they did absolutely nothing to refute or contradict his testimony. Absolutely nothing. Because it was true. I mean, At one point, he told you that magazine was never used. We have it here. He told you it was never used. You can take this back, you had all the evidence with you. But the reason he told you it was never used, he just got a picture, that he looked at it. There's not a scratch on this thing. It's a piece of plastic. It's a cheap piece of plastic. That's why it costs $20. He told you it was never used because if you put this into a steel gun, a Glock, this is going to scratch.
There's no evidence to support that.
Rule 11 has-
Oh.
This is pure. It's virgin, as Rule 11 said. There's no scratches on this thing. It's brand new. And they had 3 years to test it. 3 years to test this. They didn't do it. Not only did they not connect really shell casings to the magazine in Rocky's house, they didn't connect those shell casings to Rocky himself. And that's important. You heard that law enforcement submitted those shell casings for fingerprint analysis and found absolutely none on there. And I asked the tech before, they said, you could find fingerprints on a piece of metal, right? Pretty easily. He said yes. So they submitted Rocky's fingerprints for fingerprint analysis against the shell casings, and they found none. So they tried to make excuses for that, because that's another fact that's not good. So they tried to make excuses, like, have one of those bullets? These show this one's recovered. Claimed to be recovered at the scene by Mother at 11:45 with no GPS data. Anyway. They claim, Victor Flores said, yes, you do get fingerprints. My fingerprints are all over this thing right now. Okay? He said, yes, you'll get fingerprints on a shell casing. Metal, it's empty, of course you do. But then they said, well, could there be a reason why you wouldn't get fingerprints? And he said, yeah, there could be. His testimony on that was, yes, rain, water, cars, and even wind. Imagine that. Maybe wind wiped the fingerprints off the shell case. Imagine. So now my fingerprints are on this thing. Oh, there goes my fingerprints. Are you kidding me? Wind? Wind knocked the fingerprint off the shell case. That's an excuse. It's not a fact. There was one other explanation by Detective Flores that makes a lot more sense. He said, well, human contamination, like someone wiping fingerprints off shell casings, that could do it. And you know that after those shell casings were, yes. Thank you. Alex, now where am I? All right, hold on. Human contamination, that's right. Human contamination. The detective said that human contamination, like someone wiping fingerprints off a shell casing, that could do it. And you know that after those shell casings were fired, the only person with an incentive to wipe them clean would have been Relly, before he gave them to the police. Just like he wiped his phone clean of threatening messages to Rocky. We'll get to that. They didn't bring that out, we have to. So Relly wants you to believe his fingerprints weren't on them because he supposedly went to Dunkin' Donuts to get a bag to pick them up with. And you know that's not true. There's no Dunkin' Donuts open at 11 p.m. at night, especially during COVID.
Objection sustained. Objection sustained.
Well, you decide if that testimony is credible.
There's no testimony, Mr.
No, there's
Ms.
Objection
Sampson,
sustained. about when Dunkin' Donuts are open until.
That's
The
not-
jury's job is to decide the credibility of the witnesses, including all testimony that is given by that witness.
So here's what the witness said, and it's your job to decide. Bang. He said, I went to Dunkin' Donuts at 11 o'clock at night, got a paper bag from Dunkin' Donuts at 11 o'clock at night in Hollywood. And that's the bag I used to put the bullets in that had no fingerprints on it. You determine the credibility of that statement. He came in here and told you that. You also heard that law enforcement took Rocky's DNA. They actually took his DNA, despite Detective Flores saying that DNA was necessary as part of their investigation. He had to swear that to a judge. They never compared it to the shell casings, or even the magazine recovered in Rocky's house. That might help. They didn't do that. For that matter, you know that Relly's 9mm shell casings were different than the 9mm shell cartridges found in that magazine. You've seen that picture a hundred times. Completely different brands. The ones in the Relly said he found were Federal cartridge. Lululemon's cartridges were made by Sig Sauer. Completely different. Again, on that point, you heard the magazine was never used, was fully loaded, meaning 2 cartridges were not missing from it, but they were different bullets anyway, so it doesn't matter. Lest there be any question that that block magazine in Rocky's house was not the magazine seen in the video on November 6, 2021. All you have to do is look with your own eyes. All you have to do is look with your own eyes. So after this part, I think we can stop it, but let me just go through this last thing. The Glock magazine seen in the video is different. The Glock magazine recovered, which we just showed you actually, is a Glock 43 and it's black. Black, that's the magazine. The magazine that you're going to see in Rocky's prop gun on November 6th was not black. It was extended, as Lululemon told you, to look more intimidating, because it was a little thing, Glock. And if you look at it, you're going to see what it was. But don't forget, 12E and Lou both said, and the prosecution sort of mocked this somehow in their summation, they said, oh, conveniently they both identified the belt and the extended magazine, so they both could identify, you know, the thing. They conveniently came up with these 2 different things to be able to say it was the same prop gun. Not conveniently. Look at the picture. That's what it was. Lou put it together, and 12 saw it. That's the magazine in the, okay, I know what we're doing here now, thank you, Jen. That's the, we'll use that pointer again in our arm.
Yeah, you see on the screen.
Oh, I was too hard on the screen.
Yeah.
Sorry.
Yes.
I was pushing through it. Did everyone see here? No, okay. Anyway. That's the magazine recovered. Here's the prop gun. I'm going to try and do this where. How about now? We're good? All right. That little thing at the end is the belt clip. That's a clip. And that's what Lululemon described. Here's what you see. This thing, this clear, silvery looking thing, is the extended magazine that Lululemon described, that 12B described. It's part of this Glock prop gun, and it's an extended magazine. So it makes this thing look bigger, and they both described it as clear. This is the first time, because if you play this in real time, you'll never see that thing. We stopped it. And so here is the magazine, the extended magazine, to make this thing look bigger, and it's clear. It's not that. It's clear. Okay.
We'll break now.
Yeah,
All right, folks.
all right.
We'll resume at 9 tomorrow. Please don't discuss the case amongst yourselves or anybody else. We'll see you tomorrow, 9.